Hello everyone, I'm happy to be here with you. You see me presenting a paper with 10 authors, and this paper has been around since 2019, and you're probably wondering what I'm doing. So let me tell you the backstory. Okay, the backstory of this field is that back in 1997, for the first time, we got the ability to appeal a SEBI order at the Securities Appellate Tribunal. Okay, prior to that, the SEBI orders were appealed in front of a civil servant of the Ministry of Finance, and that is not appropriate. Later on, other regulators also got appeals process that went to the SAT. In 2013, this happened with PFRDA, and in 2014, this happened with IRDA. The FSLRC proposal was that there should be a unified FSAT, the Financial Sector Appellate Tribunal, where appeals against all orders of all financial agencies would go. And towards that project, in 2014 and 2015, we had the operation of a Ministry of Finance task force, which was called the Task Force on Establishment of the Financial Sector Appellate Tribunal. This was chaired by Justice N.K. Sodhi. Okay, and this task force developed some big ideas, and this was completed in a report that was delivered to the Ministry of Finance in 2015. A little while later, a bunch of people involved in that work got together and built a paper. And this is the paper I'm presenting today. As I said, there are 10 authors. It was published as an NIPFP working paper in 2019. I've given you a short URL for the PDF file. Okay, but in that sad age, in 2019, when people wrote papers, they didn't make a good video. So I thought that we should take the trouble of making a video of this paper. And also, these questions remain live. These questions remain central in the journey of Indian legal system reform. So it's good for all of us to apply our minds and think about these things from first principles and debate what is going on and how do we think most effectively. So first, for some motherhood and apple pie, all of us agree that a well-functioning legal system is fundamental to civilization. I think of four issues. The first is that you cannot have free and fair markets, and you cannot have free and fair elections if the legal system does not work well. Okay, so the whole concept of a competitive landscape of the market economy and a competitive landscape of a democratic political system relies on a legal system that works correctly. The second is in terms of people getting into disputes. In every complex economy, there will be people with disputes. At a personal level, in terms of the working of firms, there will be disputes. And it's just a part of life. And the job of the legal system is to help people sort out disputes, achieve closure, and move on, rather than being intractably entangled in disputes. The third is to improve everybody's behavior through predictable deterrence. Okay, so the job of punishment is not retribution but deterrence. And as long as we are able to create incentives that it really doesn't make much sense to violate laws, then everybody's behavior will become better. And the fourth and deep idea, which is not widely thought about in India, this is there in the book that Vijay Kelkar and I wrote, In Service of the Republic, The Art and Science of Economic Policy, is about the trade-offs between relying on common law and jurisprudence versus creating a specialized administrative state organization that is the regulator. Okay, in India, there was a very high willingness to establish regulators where officials have power to write the law, where officials have power to enforce and prosecute disputes, and officials play the role of judicial officers in adjudicating disputes. This is the extension of the administrative state. This troubling extension of the administrative state was a response to the perceived difficulties of the Indian judiciary. Okay, to the extent that we are able to make progress on the Indian judiciary, these trade-offs would shift in favor of more common law and less administrative state, which would generally be a good thing. Okay, so these are the four reasons why it is good and important for India to build a better legal system. And this is one field where remarkably little progress has taken place in the last 30 years. And all of us in this room, in this seminar, are the diehard optimists and believers of this cause. But I'm just giving you a classification system of how to think of the gains. In this, I think it's useful and important to think of two distinct problems that we need to keep in our minds. The first and most often is, what is the probability that a case will be decided correctly? That is the heart and soul of a legal system. A good legal system is one in which cases are decided correctly. That is about the intellectual capacity and the independence of judges. And we should never lose sight that this is a game ultimately about having cases being decided correctly. And then a second goal, which I consider a subsidiary goal, is elementary process inefficiencies. Okay, so it's good to remove elementary process inefficiencies, but just to caricature the extent to which there can be a trade-off between these two if done badly. Here is an example. Okay, I take some AI system, I take some chat GPT, it takes documents from two plaintiffs and it writes an order, and that will get the order done in 1 millisecond and it will be filled with garbage. Okay, so cases will be routinely decided wrongly, and that is the worst possible outcome we can have. But apparently it's all very crisp and efficient, and you've got tremendous process efficiency. So we should be very mindful that it is possible to construct many IT-centric shortcut through which you will appear to move very fast and you will get to a decisive outcome. But if it involves a trade-off where we will have cases be decided wrong, then that would be a terrible mistake. So we should always have this primacy that our job first and foremost is to have more cases be decided correctly. And then as a second priority, we should be improving the friction, we should be improving the process inefficiency. And I'm also going to show some ways in which better processes will help improve the same judges, holding intellectual capacity and independence of judges intact. Improved processes will help have more cases be decided correctly. So there are ways in which to do this that will actually cater to the goal. But I want to be cautious about a simplistic IT-centric approach that will not get us to cases being decided correctly. What are conventional solutions that are widely known? There are two solutions that are widely talked about in India. One is to have more judges. Okay, my discussant Shubho Roy is the pioneer in India who has spent half of his adult life on debunking this idea that you need more judges. You just need to use the same number of judges more effectively, and we will solve problems in that fashion. The second is superficial use of computer systems. At first blush, there are a lot of computers in the Indian legal system. I think I heard Siddharth say that in Kerala there are 22 different software systems running inside the High Court. Okay, so there's lots of use of computers, but it has not been thought through at a deeper level, and it doesn't add up to effective process engineering of the work of the court. Okay, and I want to show one important research product which gives us insights on this problem. During the pandemic, all over India, there were a large number of services firms who rapidly bounced back to pre-pandemic levels of output through work from home and a great deal of process engineering. Okay, so we know this. There are 50 different ways in which we can measure this, but services output in India got back to pre-pandemic levels under work from home and under gains from intensive process re-engineering. So how did the Indian judiciary fare? Manivannan, Thomas and Ajay Shah have a very important paper in 2022 where they take a deep dive into the working of one Indian tribunal, the NCLT. And the quick headline of their answer is that in the physical environment, NCLT was doing 6 disposals per courtroom day, and in the post-pandemic environment, NCLT was doing 3 disposals per courtroom day in the video environment. So this shows that while trying to use computer systems, the NCLT got a 50% decline in the output per courtroom day. Okay, and this is unique. I can't think of any other services activity in India where there was such a large decline in the productivity. And this raises deeper questions of how do you use computers? How do you do process engineering? How are you able to synthesize the wonders of modern science and technology in order to get work done? And this raises basic questions about the process engineering. So we've seen process transformation all around us in India today. For example, the great NSE and SEBI reforms of the early 90s created a transformation in the equity market and got great improvements in the working of the equity market. Similarly, today in India, banking works much better than it used to, and so on. How can we bring this kind of transformative change into the working of courts and tribunals? That's the question that we should be addressing. And this won't come from superficial use of computer systems. The present worldview is that by and large, court processes have been held intact, and we're just putting a computer layer over this, and that's not delivering very good results, as seen in this remarkable natural experiment in Manivannan et al. 2022. The first big idea we want to propose in this paper is to push the distinction between judicial and administrative functions of courts. These are two very distinct activities within a court. In the UK, the judicial work is defined as allocating, listing, and deciding cases. That is judicial work. And then there is a whole machinery of the administrative function that is creating the life support system for judges to do the judicial work. And these are distinct skills, and the whole point we are going to push is on their separation. Box 2 in the paper uses the analogy of a surgeon and a judge. Okay, consider the master heart surgeon. We are told that the actual work of the heart surgeon takes about 20 minutes. So all the magic of what the heart surgeon does takes about 20 minutes. But the heart surgery can take 6 hours. Why is that? Because there's a whole pre-processing and post-processing that doesn't require the heart surgeon. The patient has to be put into the operating table. You have to take an electric saw and cut open the rib cage of the patient. Before that, you have to remember to do general anesthesia for the patient. You have to expose the heart and put on a heart-lung machine and get everything ready. Okay, and then the heart surgeon walks into the room and she does her magic. Okay, the heart surgeon is the scarce resource. The heart surgeon is that magical level of intellectual capacity of doing complex work. If we ask the heart surgeon to be even present while the juniors are doing all this work, or worse, if we ask the heart surgeon to do all that work, or if we create a whole management responsibility for the heart surgeon to run the entire administrative system of a hospital, then the productivity of the heart surgeon will drop. So our job is to treasure the capabilities of the heart surgeon and create this entire life support system around her so that she walks into the operating theater, everything is ready for her, she does the 20 minutes of work and gets out. Let us not bog down the heart surgeon with all kinds of rubbish. Okay, we do this across all walks of life. Okay, every high skilled person in India must get that amazing life support system whereby she does not have to do anything, where she gets to focus, not have her mind distracted with all the rubbish, and concentrate on doing intellectual work, and then do that intellectual work at the highest possible level of capability. This is not elitism, this is productivity. This is about getting high quality work done out of finely refined machines who know only how to do that. I mean the human being, out of finely refined human capabilities that only know how to do that. Okay, and this is also about focus. If the heart surgeon has to even devote 1 millisecond of her mind to thinking about what was going on with that anesthesia, that's an unreasonable use of her mind. For the heart surgeon to do her job, she should have complete focus. She should not have to think about anything else in the room. She should just show up and do her work and get out, and not be even slightly deferential or helpful to other people. If an instrument falls to the ground, the heart surgeon should not put her hand down and pick up the instrument. She should be surrounded by 20 people who are the life support system who will do all that. This is the way to treasure those amazing extremities of high intellectual capability and get the best output out of them. Okay, everything I have said about the master heart surgeon applies equally for the judges. A good judge is an exotic piece of human capital. A good judge is an amazing intellectual. We want to protect intellectuals. We want to give intellectuals a life support system, that focus, where they only do their work and they are not distracted or troubled by anything else. They should not have to care about how the world comes together to create that 20 minutes of focus where the judge does her work. Okay, so that's the critical analogy between the heart surgeon and the judge, that the judicial function is the work of the judge. Everything else should be done by somebody else. The judge should not have to think about it. The judge should not know who does what. should not have to care, should not have to be deferential in that room about that life support system. The judge should only focus on her intellectual work. These are the treasured, scarce resources of this country. They should be protected. Their minds should be protected. They should have focus. They should have the luxury of focus. That is how we will get the highest quality and quantity of their work. Now, this is not a new idea at all. You turn around anywhere in the world, all the advanced economies are doing these kinds of things. Here are some names of agencies. In the UK, it is called the HMCTS. Okay, Her Majesty. No, now it's His Majesty's Courts and Tribunal Services. Service. We encourage everybody to go look up the HMCTS website. It'll give you interesting ideas about how these things work. But nothing that we are saying is novel. We're just going under the hood of a working institution to understand the concepts about why it works, not just that it works. So we are not mechanically copying the thing, but we are actually understanding it at a deeper level, that why does it work to have this level of attention and focus on the master craftsman, that is the judge, to protect their time, to protect their focus, to improve the use of their time, and to create conditions for intellectual capacity. If a judge is harassed and getting distracted and doing other things and worrying about mundane things, then that exacts a toll on her mind. She should not have to think about all the other things. Here's an Indian analogy. This is the TCS Passport Saver system. All of us have experienced the gains from TCS Passport Saver. What it is precisely this. It's an entire life support system of supporting staff who are doing other elements of the process, but the actual discretionary decision about whether you get a passport or not is only made by a civil servant. It is only the civil servant who exercises state discretion, and the civil servant makes the decision that do you get a passport, do you not get a passport. And the civil servant doesn't have to know anything about the life support system running around her, and the civil servant makes that decision. So this is the way we should think about it. All of us have seen what a huge gain we got in India because of the operation of TCS Passport Saver, and we should think of applying these kinds of models so that there is a process engineering layer on top of the state discretion, and that is something that only a state functionary can do. In this case, it's an individual from the executive who makes that decision, but the same analogy would work for an individual from the judicial branch in terms of the judge who exercises that discretion. Now, this idea has actually been bubbling around in India for a long time. The Supreme Court has written about these things in cases in 1997, in 2010, in 2016. There is an interesting speech by an MP in Rajya Sabha in 2015, and I already described the task force on the establishment of the Financial Sector Appellate Tribunal. The proposed name was FSAT, that was chaired by Justice N.K. Sodhi, which was set up by the Ministry of Finance in, I think, 2014. So these ideas have been around for a long time. So what is our big idea when applied to this problem? The first is that can you improve the process engineering around a judge, but then it will actually improve the intellectual quality of orders. So there is no trade-off. It's not like just putting some chat GPT to work to write orders. So let's think about it. Suppose the heart surgeon took 20 minutes to do a surgery. Okay, now suppose instead we broke that surgery into 10 blocks of 2 minutes, and further, just to play a thought experiment, we held everything in the operating theater intact, and the heart surgeon went away for a week and then came back and then again looked for two minutes. Okay, that would work poorly. What you need is for the heart surgeon to be lost in those 20 minutes. There should be no interruptions for those 20 minutes. Every master craftsman wants that level of focus. Nothing should be said to the master craftsman while she is working. So interruptions are anathema. Shift of concentration is anathema. All the great creative work, whether it is programming or writing or heart surgery or being a judge and writing orders, requires that complete focus, and there should be absolutely no interruptions. There should be no distractions. So this whole concept of being interrupted repeatedly and having to do the context switching of coming into a case, going out of the case, coming into a case, going out of the case. The same number of minutes of the judge's time, the most precious resource, the same number of minutes of the judge's time are being used, but the intellectual power is being diminished. So let's imagine there is a grand total of 1200 minutes of judicial time that is presently being allocated to a case. Now let's consider two cases. One, in the present Indian system, where we do 120 hearings of 10 minutes each. Or alternatively, imagine you do 10 hearings of 2 hours each. Okay, and ideally finish those 10 hearings in 30 days. Okay, then one judge or one bench can hold the case in their mind and apply themselves to it. So whatever be the intellectual capacity of the judges, the output will become better because they've got the luxury of the focus. That if they're focused on this over a smaller amount of elapsed time from beginning to end, and in each block where the attention paid to a case is done for a higher amount of time, then those same judges will be able to work better and more cases will be decided correctly. So in fact, if we are able to do this kind of process engineering, there's no trade-off between doing process engineering and more cases being decided correctly. In fact, more cases will be decided correctly if we do this kind of process engineering. So we are not doing a simplistic IT central approach. We are not leading with a digital worldview. We are going deep inside this problem and understanding the intellectual challenge of getting a master craftsman to work well. And then we are saying that the process engineering can actually cater to the desired outcome. Further, if you do this kind of reorganization, it may not even be the case that you require the same fixed 1200 minutes of judicial time, because in each hearing, there is the cost of context switching. Okay, so if you are context switching too much, context switching is not free. There is a whole cost of, pushing out your old stack and pulling in a new stack and filling your mind with the case. So in fact, you may even save time as compared to the conventional Indian way of a large number of hearings where just a few minutes are spent and things don't make progress. So what is our proposal? What is to be done? We propose very unimaginatively that we should steal the idea of His Majesty's Courts and Tribunal Service and build something analogous in India that is called the Indian Courts and Tribunal Service, abbreviated ICTS. And in the paper, we suggest that this organization should have three objectives. First, it should exercise leadership in the re-engineering process for court procedures. Second, it should turn around and actually implement those processes for courts and tribunals. And as with TCS Passport Saver, we envision an intensive amount of contracting. So this organization will need to have extreme mastery of contracting. And I've shown the URL of our work in XKDR forum on contracting. Contracting is a complex field. There's an entire life cycle of government contracting. And we should be using all this knowledge to do good quality contracting. It's not an easy matter to do the contracting for these kinds of projects. And many things will need to be done alongside this journey of legal system reform. And ICTS also needs to have the capability to think about this field, to do research on this field based on data sets on this field, to advise the legislature and the judiciary on all the associated legislative changes that are required to modify the process flow. So we recognize that there are deep problems why the Indian judiciary works poorly. It's not a trivial matter of building an IT system, and the difficulties run deep. They will require many kinds of legislative changes. And there is a long journey of going there. And we think ICTS can help as part of that journey. As with anything interesting in the world of public policy, this is not an IT project. Okay? Almost anything of importance is not an IT project. The battle here, the puzzle here is going to be around how will ICTS be governed. Okay, this is truly hard. It's easy to just say that there should be this agency, but when you go closer to this, it is very difficult to get the checks and balances right. So here are some thoughts on the do's and don'ts. The present legal system creates enormous rents for lawyers and the people that make up the guild. And they are deriving private benefits from the weaknesses of the Indian legal system with supernormal incomes. And they will be important advocates of not making changes to these systems. Okay, so the lawyers of India will not be very excited if the legal system starts working better and if higher capability in knowing law and making arguments actually becomes the skill rather than having human networks into the world of prosecutors and judges, as is often the case today. The second is, this is not a game of bringing in consultants and encoding present practices as software systems in the hands of obedient engineers. Okay, so just the standard consulting rhythm. Yes, Siddharth will vouch for me with a consulting background in his mind, that if you send in consultants to study how processes are done and then bring them to computer programmers and encode them, then you're not going to make progress. What is needed is to actually rethink these foundations. For example, everything that we have said today about going from first principles and thinking of the judge as a heart surgeon and recreating a world around that judge so that she will have the isolation and the focus to be able to think. That's not something that a consultant and a software engineer would have come up with. The third fundamental idea is it should not intrude upon the judicial independence that is so important in any liberal democracy. The fourth idea is that it should not induce centralization. Okay, so a lot of IT systems in India tend to veer into one national X, and that's really not a fair treatment of the richness and complexity of India. India is highly diverse, and in any case, the Constitution of India establishes the working of the judiciary as something that where there is enormous powers at the level of the High Court. So the Kerala High Court, as an example, should control how it works, and it may want to be very different from how the ITAT works. And there is a legitimate constitutional scheme that shapes the construction of the ITAT, and we should not think of any one national system that will change all this. Rather, we should create a framework where many high courts will start thinking about this and build systems that reflect their ground reality. The literacy rate in Kerala and the ability of litigants to work with submissions in writing is different from what is present in other parts of the country. So the kind of court processes that would be optimal would be different in different parts of the country or in different settings. The ITAT or the SAT should be very different from a more citizen-centric thing where you expect normal people to participate in the courts. And finally, the ICTS should have the correct governance and management capability so that it can do contracting. So it's interesting and important to visit the working of the UK HMCTS, as many in my research community have. But it's even more important to go under the hood and ask, what is the invisible infrastructure that makes the UK HMCTS work? What is the incentive story about why the HMCTS works? Because it is all too often we see that the simple creation of some organization in India with some IT system ends up having unintended consequences and takes us to a very different place. So it is important to understand this from first principles, not just to know what it does, but why it works. What are the checks and balances? Human beings are the same everywhere. There are people in the legislature and the executive who would love to lord over the legal system and exert disproportionate influence upon the writing of orders. There are lawyers everywhere who would love to become the intermediaries between the citizenry and the state and extract supernormal income. So these are not new things. This is just human nature. So how has the UK HMCTS created a whole array of checks and balances surrounding itself through which it works well? Okay, this is the interesting question to ask. So finally, how do we go from here to there? What is the appropriate sequencing and the construction of this state capacity? It would make sense to start with a small problem. Okay, so the fundamental principle, I'm stealing that chapter title from the book that Vijay Kelkar and I wrote, Sequencing and the Construction of State Capacity, where there is a whole bunch of lessons on how to sequence these things. And one of the fundamental ideas of sequencing is always do small things first, get it up and running. So we think FSAT is a nice small problem because the caseload is low, the litigants are sophisticated, and you can make mistakes there, you can do experiments there, and the consequences for human life would be smaller. These are professional litigants who are playing in the FSAT. So probably one can think that over 5 years, this can be done at FSAT. We can learn it, we can think about the checks and balances, we can watch how it recreates the incentives of lawyers and litigants and figure it out. And then this can probably gradually diffuse out all over the Indian landscape. As we know very well, the Bangalore High Court, and only the Bangalore High Court, is and should be the master of its own destiny. So it should be the decisions of the Bangalore High Court whether they want to work with this kind of agency and the extent to which this kind of organization gives customized and tailored solutions to each venue all over the Indian landscape where its services may be desired. So perhaps we can think of a 25 or a 50-year journey where this gradually diffuses out into the Indian landscape. And these are typical plausible horizons to make progress in India. None of us should have this big bang notion that we'll build it today and in 2 years it will be done and at hyper scale and we will solve the problems of society. Making any genuine progress takes a long time, and we should all gird our loins for these long battles. So I'm at the end of this talk. Thank you very much. Over to my discussant.